For more on this now, I want to bring in Evan Caminker. He's a professor of constitutional law and the former dean at the University of Michigan Law School. So, Evan, let's start with that EPA case first. The White House is calling this ruling devastating. This basically limits the EPA's ability to regulate power plant emissions. But some environmental groups actually came out today and said this could have been worse than it is. So tell us what happened here.
Well, I think it's pretty bad, actually. The question is whether or not the Environmental Protection Agency has been given authority by Congress to regulate greenhouse gases. In 1970, in the Clean Air Act, Congress generally gave the EPA authority to regulate pollutions that could cause harm to people or to the public health. In 2015, the EPA decided that greenhouse gases count as that and adopted a novel strategy of trying to shift the production of energy in this country away from dirty coal to more clean fuels such as natural gas or solar energy. The state of West Virginia brought a suit against the federal government here and successfully got the Supreme Court to decide that Congress had not, in fact, authorized the EPA to address this particular, frankly, huge climate problem. The court's language and reasoning, though, is incredibly broad, which is why I think this is another one of these huge cases issued at the very end of the term. The court announced something called the Major Questions Doctrine, where it basically held that if an agency does something particularly novel, adopts a novel approach to perhaps a novel problem that has significant economic or political consequences, the agency can't do that unless it can point to very clear statutory authority in the language written by Congress. Obviously, the Clean Air Act coming in 1970, Congress wasn't able to predict the problem of climate change, clean air gases. So not surprisingly, it regulated in general references to harmful pollutants. And that's basically how Congress regulates all across the spectrum of all sorts of regulations. Congress generally agrees on guidelines, policies, and then it delegates authority to the expert administrative agency to fill in the blanks. Our Congress doesn't have the time or the expertise to become experts in energy policy and election policy and all sorts of other things that the administrative state does. This court is basically trying to trim the sails of federal regulation by requiring Congress to do more than it reasonably can do, the result of which is essentially to say, nobody will be able to do a lot of new and novel things unless Congress can finally get around to regulating directly.
And this will certainly have a big impact on President Biden's climate goals. He has made this goal of having the U.S. grid run on clean power by 2035, and that seems increasingly unlikely given this ruling today. So let's switch to the decision on immigration. What did the court say about efforts to end the so-called Remain in Mexico policy? That's the policy where migrants wait in Mexico while their asylum claims are heard here in the U.S.
Right. So here the court actually gave a victory to the Biden administration. For the basic background is that when people illegally or arguably illegally cross the border control agents are supposed to either detain them at the border or in some cases can release them into the country on parole, but requiring them to come back to court for a hearing as to whether or not they really are allowed to stay in the country or not. In 2019, the Trump administration adopted a new policy of encouraging border control agents, if there weren't enough detention places on the border, to require people to go back to Mexico and then await their judicial, whether they can stay long-term or not. The Biden administration, when it replaced the Trump administration, repealed the Trump policy of sending everybody back across the border. And the court today upheld that that was a legal act. It had been challenged by, again, states, arguing that the administrative agency did not have the authority to overrule the Trump policy. And the court held that, yes, it did. The Biden policy can now govern.
So it is fair to say this has been a historic and controversial Supreme Court term with these rulings on abortion, school prayer, guns. We're going to have a new justice on the court for the next term, Judge Ketanji Brown Jackson. So what are some of the cases the High Court plans to take on next term?
I would point to two as being really important. One is another one of these hot button social issues, not just abortion, guns, as you just said, but in school prayer. This one is about affirmative action in higher education. Since 1978 in the Bakke case, the Supreme Court has permitted undergraduate and graduate programs to be race conscious, to try and increase the racial diversity of their student bodies, along with a large variety of other kinds of factors, to make it the best class it possibly can be. Supreme Court is going to hear challenges both to Harvard, a private institution, and the University of North Carolina, a public school, where, again, those affirmative action programs have been challenged. I think it's highly likely that the court, given the shift in personnel, will now overrule the Bakke decision and the decisions that built on it and say that race-conscious admissions is no longer valid. The other case I would really keep an eye on, the court granted review of just today, and it's a case about the state role in controlling and regulating federal elections. So our Constitution gives states the power to regulate elections for Congress, and also, as we all know, to select the electors that go to the electoral college that chooses who the president is going to be. And our Constitution refers to state legislators, not just states. And the question is whether or not the complete control over setting up the federal regulations are in the hands of the state legislatures alone, or whether they are bound by their own state constitutions. And this is critically important because we have seen in recent years, state constitutions, sometimes state courts say, well, wait, what the state legislature has done is actually a violation of constitutional rules. The case coming before the court is one where the state Supreme Court of North Carolina struck down what it thought was a politically gerrymandered set of districts for the upcoming congressional elections. And we've already seen, leading up to the last presidential election, there was a lot of argument over whether or not state courts can get involved in interpreting, well, how do you apply the state voting regime in a pandemic? What are the rules on mail-in ballots, on who has access to vote, et cetera? So the decision here as to whether or not those decisions are entirely in the hands of the state legislatures, completely free of state constitutional control, is critically important, in part because there are 30 states now where Republicans control both houses of the state legislature.
Yeah, that case has the potential to fundamentally alter how elections are conducted in this country. Evan Caminker, we thank you for your time.
Quite welcome. Thank you.